A very good afternoon to everyone. This is Radhika. Today I'll be discussing about the inherent powers of the High Court that is given under section 482, chapter 37, titled Miscellaneous of the Code of Criminal Procedure 1973. So basically section 482 deals with the inherent powers and it also lays out the provisions for quashing of criminal proceedings. So before discussing about the inherent powers, I would like to tell you about the brief background of this particular provision. So section 482 is an exact reproduction of section 561A of the Code of Criminal Procedure 1898, which was added by the Code of Criminal Procedure Amendment Act 1923. That means this particular provision was added in the code in the year 1923 as the High Courts were unable to render complete justice in the cases where illegality was apparent. Therefore, the inherent powers are used in order to secure the ends of justice. All right. So now the very first question is, what are exactly inherent powers? So section 482 says saving the inherent powers of the High Court. Basically, section 482 does not create the inherent powers, rather, it merely acknowledges or declares the existence of the inherent powers. Therefore, the inherent powers are not created, rather, it inheres in a person or agency per se. Therefore, if the High Court exists, that particular institution, that is the High Court, if it exists, then the inherent powers will automatically exist. Because inherent powers means something which inheres in that particular person or authority. All right. So now the next question is, when can the inherent powers be exercised? So as we all know that the legislature has deemed the CRPC to be exhaustive, but it cannot be exhaustive as the circumstances are dynamic and it changes according to the time. So there may be some situations where the law is inadequate or where there is no law at all. So in these cases, the court will always exercise its inherent powers. See, normally the court will act as per the express provision given under the CRPC. But there may be some circumstances where there is no provision, or if there is provision, then that provision is ineffective. Or there may be some situations that when the court has passed an order under the express provision, but that particular order is ineffective or insufficient. Or there may be some situations where the party concerned is misusing that provision of the court. So in these cases, the court can always pass an order in exercise of its inherent powers. Alright, so this was about the brief introduction regarding the inherent powers of the court. So now let us read the bare language of the section. So section 482 says, saving the inherent powers of the High Court. It states, nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to an order under this code, or to prevent the abuse of the process of the court, or otherwise to secure the ends of justice. So if we break this section into parts, the very first ingredient is nothing. That means it is a saving clause. So the word nothing has been used to suggest that despite the express provisions, the inherent powers is saved, and whenever required, the inherent powers can be used. That means the jurisdiction under section 482 is discretionary. And the court may always refuse to exercise this discretion if the party has not approached the court with clean hands. That means it is a saving clause. Now, the second ingredient. So the section says, nothing in this code shall be deemed to limit or affect the inherent powers of the High Court. That means the inherent powers can only be exercised by the Honorable High Court. Now, why these powers can only be exercised by the High Court? Because the CRPC, the Criminal Procedure Code, deals with the criminal matters. Therefore, the larger societal interest is involved and individuals' fundamental right to life and personal liberty get affected under Article 21 of the Indian Constitution. Therefore, the policy is to retain the inherent powers with the superior and experienced court, that is the High Court. But there was an issue that was raised in the case of Sakiri Vasu versus State of Uttar Pradesh, that whether the judicial magistrate can also exercise the power under this section. So in this case of Sakiri Vasu versus State of Uttar Pradesh, year 2007, two-judge bench, and the order was delivered by Honorable Justice Markandeya Katju. So in this particular case, it was held that the judicial magistrate does not have the inherent powers. The application of inherent powers can only be filed before the High Court, but the magistrates do have implied incidental or ancillary powers. Now, what does this mean? That means the magistrate can always pass an order incidental to its early order to make that early order effective. All right, so this means the inherent powers can only be exercised by the Honorable High Court. So now let's move further with the section. It says, nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to the order under this code, or to prevent the abuse of the process of the court, or otherwise to secure the ends of justice. Now we will understand these provisions with the help of a case, that is Narendra Singh versus State of Punjab, 2014 Supreme Court. So in this particular case, it was held that the High Court, in deciding the matters under section 482, should be guided by following objectives. Now what are these objectives? The very first is to prevent the abuse of the process of the court. Second one, to secure the ends of justice. Lastly, to give effect to an order under this code. That means these three are the guiding objectives. So the last ingredient talks about the objectives. So now this was about section 482. Now, as I've told you earlier that section 482 also lays out the provisions for quashing of criminal proceeding. Now, what is this quashing? So according to the Black Laws Dictionary, quash means to overthrow, to vacate, to abate, or to make void. So in other words, the quashing of criminal proceedings means to put an end to the legal machinery which is set into motion by filing of an FIR or complaint. So we will understand this with the help of a landmark case. Now the landmark case is State of Haryana versus Bhajan Lal, year 1992 Supreme Court. So in this case, a two-judge bench of the Honorable Supreme Court considered in detail the provision of section 482 of the CRPC and the power to quash the criminal proceedings under this section. So with respect to the quashing of criminal proceedings, the court laid down 7 criteria. So if the case falls under any of such headings, then the court can always quash the criminal proceedings. Now, what are these criteria? See, where the allegations made in the FIR do not prima facie constitute an offence or make out a case against the accused. So if the prima facie the case is not been made out, or where the material accompanying such FIR do not disclose the commission of a cognizable offence justifying investigation by the police officer under section 156 of the Criminal Procedure Code, then also the court can always quash the criminal proceedings. Or when the allegations made in the FIR and the evidences collected in support of the same do not disclose the commission of an offence, then in that case also that the court can always quash the criminal proceeding. Now there are certain other criteria also which include that where allegations made in the FIR are so absurd to the extent that no prudent man can ever reach to the just conclusion that there exists a situation or sufficient ground for proceeding, or the proceeding are so maliciously instituted with an ulterior motive, for example due to some personal grudge, etc. So in these cases the court can always quash the criminal proceedings. All right, so this was about this. This is just the landmark case regarding the quashing of criminal proceeding. Now we will discuss some of the recent judgments regarding this section 482. So the very first judgment is State of Madhya Pradesh versus Lakshmi Narayan, and the judgment was delivered on 5th of March 2019 by Honorable Mr. Justice M.R. Shah. So in this particular case, a three-judge bench of the Honorable Supreme Court has has issued guidelines regarding the quashing of criminal proceedings on the ground of compromise between the parties. So this particular case talks about the compoundable offenses. Now, what are these offenses? So, compoundable offenses are those offenses in which the parties have resolved the entire dispute among themselves. All right, and this provision is dealt under section 320 of the CRPC. All right, so see, in general cases, the compounding is done under section 320. But section 482 is attracted in cases of non-compoundable offenses. All right. So section 480, so the powers conferred under section 482 regarding the quashing of criminal proceeding for the non-compoundable offenses can be exercised mainly in proceedings which like having civil character. So the proceeding having civil character can only be quashed under section 482. For example, disputes regarding matrimonial relationships, family disputes regarding commercial arising out of the commercial transactions, or any other dispute that has been resolved by the parties among themselves. So these are not that serious offenses. They have, like, they are of civil nature. All right, but the inherent powers are not to be exercised in the cases which are where the prosecution involves heinous or serious matters. For example, rape, murder, dacoity. So these type of offenses are not of private nature, rather affects the society at large. That means these type of offenses like rape, murder, dacoity, these are crime against the entire society. So that is why the court cannot quash the criminal proceeding in these cases. So for example, offenses under section 307, that is attempt to murder, or offenses falling under any special statute like Arms Act or Prevention of Corruption Act. So in these cases, the court will not exercise its power under section 482 of the CRPC. All right. So in this particular case, the court also held that while exercising the powers under section 482, in respect of the non-compoundable offenses, the court should consider in detail the antecedents of the accused, the conduct of the accused, and how the accused managed to enter into the agreement, that is compromise between the parties, or that with the complainant. So court has to consider all these factors. All right. So these are some of the guidelines that the court has given in this case, that is State of Madhya Pradesh versus Lakshmi Narayan, regarding the quashing of criminal proceedings on the ground of compromise between the parties. All right. So now the next case, which is Ramesh Chandra Gupta versus State of Uttar Pradesh. Now the judgment was delivered on 28th November 2022. So in this particular case, the court reiterated the guidelines given in the case of State of Haryana versus Bhajanlal. So basically, the court emphasized on two criterias. That is point number one, the criteria number 1 and criteria number 3. That says, where the allegations made in the FIR do not prima facie disclose or constitute the commission of an offense or make out a case against the accused, or where the allegations made in the FIR or evidences collected in support of the same do not disclose the commission of a cognizable offense. So in these cases, the court can always quash your criminal proceedings. So this was discussed in the case of Ramesh Chandra Gupta versus State of Uttar Pradesh. All right. So now the next recent case, that is Central Bureau of Investigation versus Aryan Singh. Now, this particular judgment was delivered on April 10th, 2023. So, this is a very recent judgment. So, in this particular case, the court held that as per the cardinal principle of law, as per the cardinal principle of law, at the stage of discharge or quashing of the criminal proceeding while exercising the power under section 482 of the CRPC, the court is not required to conduct a mini trial. So, as I have told you earlier that the main objective is to avoid the abuse, and the court should not exercise these powers arbitrarily to cut short the normal or ordinary process of the criminal trial. So, while exercising these powers under section 482, the court cannot conduct a mini trial. So, all right, these are some of the recent judgments. Now, at last, we will discuss some of the limitations of the use of section 482. So, firstly, inherent powers under section 482 can only be exercised in cases when no other legal remedy is available to the litigant. So if a legal remedy is been provided under any statute, then in that case the court would not exercise its power under section 482 or will not exercise the inherent powers. That means the inherent powers can only be exercised in the cases where no other legal remedy is available to the litigant. All right. Now, secondly, while exercising the powers under section 482, the court will not act as an investigating authority. So, in order to examine the factual content of the case, the court will not act like a police officer or an investigating authority. So, this was the second limitation. So lastly, as we discussed earlier, while exercising these powers, the court would not conduct a mini trial. So the main objective, that is to prevent the abuse of the process of the court would not act arbitrarily and would not cut short the normal process of the criminal trial. All right. So these are certain limitations regarding the quashing of criminal proceedings. So I hope I'm clear to you guys. But see, as I conclude the whole, the scope of section 482 is quite wide, and in order to prevent the abuse of the process of the court or to secure the ends of justice, it has to be used wisely and according to the guidelines laid down by the Honorable High Court and Supreme Court. So I hope I'm clear to you all. So thank you so much.